Madam Speaker, I rise pursuant to Standing Order 52.2 of the Standing Orders to make a statement concerning access by county governments to their share of national raised revenue for financial year 2020-2021. Madam Speaker, as you are aware, under the Constitution of Kenya 2010, there is a two-tier process on how revenue is shared between the two levels of government. In the first instance, and pursuant to Article 218, 1A of the Constitution, Parliament considers and passes the Division of Revenue Bill, which provides revenue raised nationally divides revenue raised nationally between the national and county levels of government. In this respect, the Division of Revenue Act of 2020 was passed by Parliament and assented to on the 22nd April 2020. In the second instance, and pursuant to Article 218, 1B of the Constitution, Parliament considers and passes the County Allocation of Revenue Bill, which allocates among counties the revenue allocated to the county level of government on the basis determined in accordance with the resolution passed under Article 217 of the Constitution. The County Allocation of Revenue Bill 2020 was published on 17th April 2020, read the first time on 21st April 2020, second reading, debate on the bill commenced on the 5th of May 2020 and was adjourned, pursuant to Standing Order 105, to allow the Senate to consider and pass the third basis for allocating revenue among counties, the share of national revenue that's annually allocated to the county level of government. The passage of the County Allocation of Revenue Bill 2020 is predicated upon the resolution made by the Senate pursuant to Article 217 of the Constitution, considering that the second generation formula has lapsed. Madam Speaker, Article 224 of the Constitution provides on the basis of the Division of Revenue Bill approved by Parliament under Article 218, each county government shall prepare and adopt its own annual budget and appropriation bill in the form and according to the procedure prescribed in an Act of Parliament. However, while a reading of Article 224 would seem to imply that the budget process at the county level of government is determined by the Division of Revenue Bill, it should be noted that Article 224 is operationalized where there is a subsisting basis for the horizontal allocation of the county government's share of nationally raised revenue among counties. Madam Speaker, a consideration of this synopsis of events therefore reveals that with respect to this financial year, we are in a very unique situation where the vertical allocation of counties is ascertainable from the Division of Revenue Act, while the horizontal allocation determined by the County Allocation of Revenue Bill is yet to be ascertained, as it depended upon the resolution of the Senate under Article 217 of the Constitution. Madam Speaker, the budget-making process and allocation of revenue between the two levels of government is not merely an academic exercise. At the heart of the public governance is the delivery of public service. The efficient and effective delivery of public services is dependent on resources. The delay in passage of the County Allocation of Revenue Bill not only represents a delay in the transfer of funds to county governments, but is likely to result in the crippling of services at the county level of government. We are almost at the end of the first quarter of this financial year, and no transfer has been made to county governments. A delay in the determination of allocations due to county governments will ex ante cause disruption in the budget-making process for county governments and ex post affect the effective implementation of the budget. These two scenarios therefore beg the question whether county governments have a remedy within the law that would allow limited access to their share of the nationally raised revenue. I would like to first call your attention to the provisions of Section 134(1) and 2 of the Public Finance Management Act, which provides if the county appropriation bill for a financial year has not been assented to or is likely to be assented to by the beginning of a financial year, a county assembly may authorize the withdrawal of money from the county revenue fund. Money withdrawn under the subsection 1A may be used only for the purpose of meeting expenditure necessary to carry the services of the county governments during the financial year concerned until such a time as the relevant appropriation law is passed. And B, may not exceed in total one half of the amount included in the estimates of the expenditures submitted to the County Assembly for that year. So, Madam Speaker, the provisions of Section 134 of the Public Finance Management Act, however, contemplate that the option of votes on account would arise where the Division of Revenue Bill and the County Allocation of Revenue Bill have been passed, and for whatever reason, a County Assembly has not passed an appropriation bill. The section does not contemplate the present situation where the County Allocation of Revenue Bill has not been passed and national revenue has not been divided among counties. So, Madam Speaker, perhaps the provisions of the Public Finance Management Act, county governments, regulations, would provide a clearer way forward. Regulation 134 of the Public Finance Management Act, National Government Regulations, provides this way: that for equitable transfer before approval of County Allocation of Revenue Bill, if the County Allocation of Revenue Bill submitted to Parliament for the financial year has not been approved by the Parliament, or it is not likely to be approved by Parliament by the beginning of the financial year, the Comptroller of Budget may authorize withdrawals of up to 50% from the Consolidated Fund based on the last County Allocation of Revenue Act approved by Parliament for the purposes of meeting expenditure of the county governments for the financial year. 2, the authority under paragraph 1 shall cease upon assent of the County Allocation of Revenue Act for the financial year. And 3, the transfer to county governments made under paragraph 1 under this regulation shall form part of the equitable transfer for the financial year. It is prudent to remember that these regulations are made under authority conferred on the Cabinet Secretary under Section 205 of the Public Finance Management Act and under the principles espoused under Article 94(5) of the Constitution. It is my unequivocal position that whereas the principle of Act does not deal directly with the question of transfers in the absence of County Allocation of Revenue Act, the regulations are clear on the remedy available to counties. Madam Speaker, the conundrum we are faced with has been the subject of judicial consideration. In advisory opinion number 3 of 2019, the Council of Governors and 47 others versus Attorney General and 6 others, the question of funds transferred to county governments in the event of a delay in the process of enacting Division of Revenue Bill was canvassed by the Supreme Court. The following constitutes the court's ruling on the matter. It is therefore our considered opinion, this is a court's ruling, it is therefore our considered opinion that should an impasse occur during the failure of the mediation process, occasioned by the lack of concurrence between the two houses over the Division of Revenue Bill, the National Assembly shall, for the purpose of meeting the expenditure necessary to carry on the services of county government during that year, until such time as the Division of Revenue Act is assented to, authorize the withdrawal of money from the Consolidated Fund. The money so withdrawn shall be included under separate votes for the several services in respect of which they were withdrawn. It is to be expected that each county assembly would have to readjust their respective budgets and appropriation bills accordingly. This leaves us with a question regarding the percentage to be withdrawn from the Consolidated Fund. While the withdrawal of money for the purpose of the national government under Article 222 is based on the percentage of the estimates of expenditure for that year, the same method cannot apply to the county government, since the monies do not include the equitable revenue share due to the counties. Logic would require that the percentage of the money to be withdrawn be based on the Division of Revenue Bill. Yet this would be legally untenable, given the fact that the bill is not only the subject matter of a controversy, but is also yet to pass into law. In the circumstances, it is our view that in the event of an impasse, the percentage of the money to be withdrawn be based on the equitable allocation to counties in the Division of Revenue Act of the preceding year, financial year. In keeping with the spirit of Article 222(2)(b) of the Constitution, the money to be withdrawn shall be the 50% of the total equitable share allocated to the counties in the Division of Revenue Act. Madam Speaker, at the outset, let me point out that the Supreme Court advisory opinion relates to the situation where the Division of Revenue Bill has not been enacted. This is distinguishable from the present scenario where the Division of Revenue Act has not been enacted and the county's share has been enacted, and the county's share of nationally raised revenue has been determined. Access to these funds will therefore not be subject to the approval of the National Assembly or be predicated on the passage of an appropriation bill. The global allocation to counties has already been made by the Division of Revenue Act. However, the advisory opinion remains useful for our present purposes as it would have the same net effect that we are trying to achieve. The directions of the court would result in the transfer of 50% of the allocation made to each county government in the immediate preceding financial year. Indeed, the manner in which the court arrived at this conclusion is aligned to my statement today. In considering the question to access of funds by counties during the delay in the enactment of legislation contemplated under Article 218 of the Constitution, the court employed a purposive interpretation of the Constitution. They based their opinion on the overarching principle of continuity in government as set out in Article 222 of the Constitution and espoused in the rulings of the Supreme Court. The court found that a reading of the law whose consequence would be the grinding to a halt of a delivery of services by the county governments would represent a subversion of Article 222 of the Constitution, and yet a constitution cannot subvert itself. There must therefore be a remedy for counties to continue delivering on public services. Madam Speaker, on the premise of the law and facts that I have canvassed above, therefore it is incumbent upon the Cabinet Secretary of the National Treasury to implement provisions of Regulation 134 of the Public Finance Management Act, the national government regulations, and further fortified by the ratio decidendi of the court in advisory opinion number 3 of 2019, to transfer to the counties 50% of the allocation made in the County Allocation of Revenue Act 2019. This would ensure that the continuity of the delivery of services by county governments as a means to an end, but also as a means of promoting the principles of devolution as set out in Article 175(b) of the Constitution. Madam Speaker, I raise this statement because of the misunderstanding, Madam Speaker, and also, Mr. Speaker, just to disabuse the nation of these accusations that come or are targeted to us in the Senate, Madam Speaker. And I know that my colleagues probably, I'll ask, my colleague, the leader of my minority, will add his voice to this as soon as I conclude. But, Speaker, I think it's very clear that we have a duty to do in determining the formula and also in passing CARA. But for this moment, as the counties, it is very difficult for the Senate not to come out in this manner. And we had to do this because you can hear even governors accusing the Senate. And Madam Speaker, you can hear governors saying they are going to grind to a halt. And everybody knows that the Constitution protects that. It cannot happen. And we should not allow it to happen. So we have come out, and I'm going to table this statement and ask that my colleague, the leader minority, adds his voice to this. Madam Speaker, thank you.
Leader of Minority.